Just got off a plane last night from coming back from Key Largo, and yesterday morning I was swimming in the Florida Bay. It was like a bathtub. It was warm. There was barely a ripple. And then I heard Kurt talk about his daughter's tangled hair. So it was sort of in the middle of both, between this calm, balanced, set process years after today, and the tangle of hair where everyone's confused, no one knows what's going on, and it's been a long, arduous process, if that makes any sense by analogy standards. My name is Barry Werbin. I'm a partner here at Herrick Feinstein. We're thrilled to be able to host this today. I head up our intellectual property practice, which includes representing trademark owners, prosecuting trademarks, infringement claims, UDRP arbitrations, and occasionally defending against trademark claims and the like. And I'm very happy to have been asked to participate. I'm going to kind of wing it. I don't have a set of prepared statements, but I want to go through a few things that are very important to understand from a brand owner's perspective. ICANN has worked very, very extensively with interest groups in this space, particularly the International Trademark Association, of which I'm a member on their Web 2.0 subcommittee, which has participated through multiple rounds with ICANN to try to strike a balance. ICANN was formed under an agreement with the U.S. Department of Commerce years ago, is still under obligations to abide by certain policies, which Kurt alluded to in his keynote speech, including to promote competition, fairness, and maintain security throughout the entire domain name process. And I think the latest iteration of the guideline application book seeks certainly to reach that balance. It's not perfect. There are still issues. Brand owners have concerns, but it's come a long way in a very, I think, positive strain. Can we get my slide up? Just to show you the complexity of the process, I have a slide actually out of the application, the current iteration of the guidebook, which came out, I think, beginning of June, May 30th, right? And it's actually a two-page flow chart of the entire application process. Can we get that up? And what this emphasizes is, in my view, the need for, I think Roland and Mike both, I think, mentioned at some point, a team approach, because you can't do this from a company internally with your existing staff. In my view, it's a combination of marketing and business people, inside, in-house, and outside counsel and experts, because there are legal issues, there are business marketing issues, and there are extensive infrastructure technical issues. And in fact, once your application passes the initial review processes and gets the green light from ICANN, there's still a final technical administrative testing phase that ICANN will put you through to make sure your DNS is secure, you've complied with the security, and in a real world, real load situation, it actually functions properly. So we're not going to go through this, we don't have the time. The guidebook is available on ICANN's website. Obviously, anyone who's interested in applying for your company's legal marketing side, it's a must-read, despite it being over 300 pages. You cannot avoid it if you want to go into this process. But you can see, if you follow it from the top down, this is sort of module A or part A of the process, which you have to pass, the green light go to get to the second phase. The green boxes, sort of the bottom third, are various categories of objections that ICANN can issue in the initial review process. Again, I'm not going to get into the technical aspects of it. One of the things from a trademark point of view, and this will be discussed in a later panel, deals with geographic names. Country names are prohibited from GTLDs without getting into additional details. City names may be permitted with consent of the state, of the city and their state. Again, there's this whole specialized process and review process for that. If you pass this, can we get to the next one? Just scroll up, sorry. Yeah, great. If you pass this, the initial review process, then there were various protections and mechanisms set up to protect rights owners. We're talking really about trademark owners, brand owners. And you need not have a registered trademark to file an opposition. The trademark claims process, which is what it's referred to, can protect both registered and unregistered trademark owners. Why is that important? Because the trademark protection laws vary between countries, and you have really two categories. One are countries, which are the majority, not including the U.S., that protected mark merely from registration. In the United States and a couple other countries, trademark rights are not protectable until you actually start using a mark in interstate or in commerce. So registration provides additional valuable benefits in the United States, but it is not necessary to have enforceable rights. Enforceable rights in the U.S. are derived from use of a mark in commerce. In the EU and most other parts of the world, you can have and obtain enforceable trademark rights merely from registration and not from use. So until usually 3 to 5 years when it can be challenged for non-use. So ICANN had to initially come up with a balance, and that was one of the issues that had to be addressed from a trademark rights viewpoint, whether only registered mark owners would be able to enforce their rights. That was ultimately expanded to allow unregistered mark holders to file oppositions as well. The test is similar to what we find and use in trademark infringement cases here and similarly in the EU and other parts of the world. It really comes down to whether there is a substantial likelihood of success. It can't just be conjecture or it may cause confusion. It has to be a very strong likelihood of confusion. And there's various factual assessments that go into that, including the bona fides and intent, good faith intent of the applicant, whether the applicant has actually used that particular mark in its own business before filing its application, the strength and renown of, or the strength and protectability of the opposer's mark, and various other factors, and finally the most important, whether there is a strong likelihood that the applied for new GTLD will create confusion or as to source, origin, or sponsorship with the brand owner's marks. ICANN is hoping that some of these will be resolved amicably by agreement or mediation. Those that are not will go through a special arbitration process, not that dissimilar to the UDRP we have now. Everybody know what the UDRP is? The Uniform Domain Resolution Procedure, which is mandatory for all registrars and anyone who registers a domain. It provides a sort of a fast-track, relatively inexpensive, not always, arbitration procedure to resolve essentially trademark claims against cyber squatting and the like. WIPO will administer arbitrations brought by trademark owners. There's a second type of objection that can be filed by trademark owners and others as well, which is referred to as string contention. And string contention, I think, right now will come up really towards the end of the process before ICANN actually approves and I think releases a domain, TLD for delegation to a new registrar. The string contention refers to the actual domain string that's sought to be registered, where it's the same as or substantially similar to an existing GTLD. And that can be not only for a brand owner that has an existing GTLD, but in particular for competing applications. And here's where an auction, the auction process can come in. If two applicants for the same GTLD are competing, that can invoke the string contention process. If they can't work it out amongst themselves and come up with a variation, then it'll either go to an auction or it can go into a specialized arbitration process, which I believe is going to be handled by an organization here in New York. It's the International Dispute Resolution, I forget the last part of it, organization, just here in New York City. which has agreed to handle those string contention disputes. So we have various forms of protection along the way during the process. What are the considerations that a company should consider whether or not they should either wait on the sidelines to file dispute resolution procedures and oppositions, or file their own applications? Well, first is a question of money. If you're dealing with a large multinational consumer brand company like Canon, we're always using Canon because they were early to announce their intention. Canon, for example, is going to announce that everyone who buys a Canon camera will be issued a second level domain. So if I, to the left of .canon, so if I buy a new Canon, I can get barrywerbin.canon. So as soon as I take my photos, I can post it essentially to my own barrywerbin.canon website directly. It's a great marketing idea. And from Canon's point of view, this is all about marketing. And although the costs are objectively significant, $185,000 is the initial application fee. That could certainly escalate if you're getting into a bidding war and an auction over a generic name. But even aside from that, there could be objections filed by ICANN. There could be third-party oppositions, all of which can escalate the cost. You then have to set up an infrastructure. You're becoming a registrar, and as we've heard here, you really can't do that on your own. Again, that goes back to the team approach. ICANN will put you through I'm sure, fairly rigorous test process at the end to make sure you really can do what you say you can do, even if your application is tentatively approved. But for a large multinational, national company, even if you're spending $500,000 and then there's a $25,000 minimum administrative fee every year to maintain it, it's a 10-year registration. It can be extended, renewed. It's a 25 for every domain. If it's an open registry, for every domain over 50,000 is a 25-cent additional fee. Over the 25,000, you have to have employees, you have to build out infrastructure, hardware, and all that. In addition, you have to post a bond. I think it's in the form of a letter of credit to cover at least all your anticipated expenses for the first 3 years. There are substantial financial disclosures that have to be made as part of your process. So tremendous amount of thought, time, and effort has gone into this process, and all this has to be factored in. Some of the concerns brand owners do have, and the IATA, International Trademarks Association, still has, is obviously preventing confusion with the potential explosion of new TLDs. The potential for diluting brands is out there. Many companies may choose, instead of applying for their own TLDs, to file for defensive registrations, which we see now. In the early days, we had all these gripe sites, the sucks sites. So if someone didn't like something Herrick Feinstein did, they would register herricksucks.com. And there wasn't much you could do about it because we have something called the First Amendment in the United States. If you were voicing your opinion and griping, it was protected by the First Amendment. So we've always advised companies, go out and register iterations of all your brands followed by sucks and your company name top by sucks, just to park it and keep it off the market. Well, this may be a great boon for business for all the new registrars. As I think we'll see a lot of defensive registrations as well coming down the pike, particularly if dealing with generic TLDs. Concerns about fraud, scavengers. I can't tell you, we all in the trademark bar, we have clients constantly contact us about the emails we get from Chinese registrars. Some are real registrars, some are not. About someone has applied to register your name as a domain, maybe .hk, might be whatever, China, whatever, and they're not legit, because they'll get you to respond. They got a live fish on the hook, and then they'll try to pull you in. And I'm not going to expand on that, but those kinds of scams are obviously a concern. It becomes more of an effort administratively on the legal side and on the administrative side to track hundreds, if not potentially thousands, of new TLDs over time. And the last thing I want to say is we don't know what's going to happen because we don't have empirical data. except to a very limited extent. At the end of, in late 2010, ICANN commissioned a high-level economic study, which issued a report in December. And it was equivocal, in my view. It said, economists concluded it was insufficient empirical data to assess whether, in fact, the new system would promote competition. It's really what they were looking at. They cited, for example, I think Roland mentioned Dot Museum. 40,000 museums in the world, about 1.5% actually registered a .dot museum domain. Why? Because they all go with .org, they're not-for-profits. They didn't see value in it. .mobi was supposed to take off, it never did. How many of you have ever seen a .aero, A-E-R-O, domain? You don't see it. Some, there's a few. Someone raised their hand back there. Maybe you own one. The registrars know more about than me, but. So the statistics, we don't have enough. We have 22 top-level domains currently, and I guess time will tell. The economic report had recommended a more slow, controlled rollout in limited numbers of new TLDs, and I think ICANN has indicated that in the first phase it would register up to 1,000 now, new GTLDs. It sounds like a lot. One could argue it's not, but from an administrative legal point of view, it certainly increases the headache. And I think we're going to see a lot more costs incurred by companies, both proactively as well as defensively. So it's really
Thank you, Barry.
Points. Next.
Next, I have Ben Crawford with That Brand Solutions.
Okay, I'm going to get up there.